Okay, it's 12 o'clock Central Time, so it's time for the Snodgrass Partners Webinar Tuesday. So welcome to the SMU Sport Management Virtual Campus as we present today's Intercollegiate Athletics webinar. As you know, or those of you who've been here before, I like to banter a bit before we begin, but today's topic is one that is evolving on a daily basis. So I would much rather yield my time to our learning and education, and I'll do that. I'll be brief in my remarks this morning. So first of all, welcome everybody joining. I recognize a number of the emails that have returned to see us again, but then there are quite a few new ones as well. And this week, actually, quite a few outside of .edu, which is interesting. So everybody, welcome. We will be recording this. We are recording this, so you could see it at a later date if you need to, or if you want to share it beyond, that is fine as well. My name is Peter Davis, and I am an adjunct professor at SMU in their Sport Management Master's program here in Dallas, Texas. Last week I complained about the heat in Dallas, so the weather gods laughed at me and turned it up a few more degrees. Oh well, that's what I get for moving to Texas, I think. So each week, SMU and Snodgrass Partners try to share with you some really relevant perspective on the world of intercollegiate athletics. And most of it has to do with what's going on today. How can we help you today? And that's reflective of the Snodgrass Partners consulting practice, helping with intercollegiate athletics and athletic department needs immediately. However, Snodgrass Partners also consults on future strategy development. And that's what we're going to look into a little bit today. As I said, it's an ever-evolving topic of NIL and student athlete compensation. There's a lot to know. It's not much you can do with it today because we still don't know what's coming, but it is an evolving topic, and we want to make sure you are kept top of mind or keeping this top of mind and provide you some insight into what you can do to make sure you are preparing for it when it becomes very real. And it certainly seems that that will be happening. So today's guest is Mitt Winter. He's joining us from Kansas City and his law firm, Kennyhertz Perry, there in Kansas City. Mitt is a former student athlete. For those of you that have been with us a few times, you know that I love to have former student athletes on. So indeed, Mitt is a Division I basketball player in his past, and today, obviously, he's moved that forward. But in so doing, I'm sure he's paying attention to the scheduling this fall and what's going on with fall sports, the craziness that's going on there. But I'm sure he has a keen eye on Danny Gavitt and the NCAA and what they're doing to the winter sports and the start of whether that's November 1st or 2 weeks earlier or 2 weeks later on the start of basketball season. But in today's real world, Mitt is focusing on law, and he's a tremendous attorney with some great breadth and depth of experience, but he's got an expertise and a real interest in the intercollegiate side of things. Those sorts of topics. He's worked with some major national footprint law firms, and he's represented people like Stanford, the NCAA, the Big 12, Conference USA, among others. And he's very well known for his work in Title IX, in scholarship valuation setting, conference realignment, media agreements, and other business litigation type matters as well. And with such a breadth and depth of knowledge, Mitt is ready to share his information today, but also we would encourage you to share questions you have as we go. So as you do mouse around your screen, you will see a Q&A button. So please feel free to click that at any time. There's a comment section as well that I'll be watching, but the Q&A is probably the easiest. So as I get questions, I can share those with Mitt as we go. I can't promise we'll get to them all live today, but any questions that are input, we will certainly get back to you if we lose time at the end of today. So we've got about 45 minutes to run, and with that, I'm just going to get out of the way. I'm going to turn over the trackpad and the screen to you, Mitt. Let you share some insights with us today, and I'll jump in as questions pop up. But the floor is yours.
All right, thanks, Peter.
Of course.
All right. As Peter said, my name is Mitt Winter. I'm an attorney at the Kennyhertz Perry law firm in Kansas City. And today we are going to go over a legal perspective on name, image, and likeness, legislation and rights for college athletes, and college athlete compensation, and then gives some tips on what universities and others can do to prepare for changes that are coming. Give you a little background on myself and my practice before I jump into everything. As Peter said, I'm a former college athlete. I played basketball at William and Mary. I was there from 1997 to 2001. I also have a brother who was a Division One college basketball player, and my dad also played basketball in college as well. So I'm very familiar with what it means to be a college athlete and how college athletics works behind the scenes. In my legal practice, I have worked on a number of college athlete compensation cases in the past 15 years, in addition to the other types of intercollegiate athletics areas that Peter mentioned earlier. It seems like these cases have just kind of followed me around as I've moved. After graduating from William & Mary, I moved to San Francisco, went to law school out there, and then worked for a big law firm out there. And while I was there, I represented the NCAA in the White versus NCAA case, which was brought by former basketball and football student athletes, alleging that at the time the NCAA's limits on athletic scholarships, tuition fees, room and board, and books was an antitrust violation. And they were seeking to have that limit raised to the cost of attendance, which, as most of you on this webinar probably know, is the current allowable amount for an athletic scholarship. That case ended up settling, no rules changed. Money was put into the Student Athlete Opportunity Fund, Student Assistance Funds, but no rule changes came about of it. Then I also did some work on the O'Bannon case, which a lot of you are probably familiar with. At that time, I had moved to Kansas City, and I was representing the Big 12 and Conference USA, who were not parties to those lawsuits. The NCAA was the only defendant, but the Big 12 and Conference USA were definitely very interested third parties in that case. And this was the first case that found that NCAA rules violated antitrust laws. Interestingly enough, this was a name, image, and likeness case. Ed O'Bannon, a lot of you know the story, saw himself in a video game. He filed a suit. It was turned into a class action alleging that the NCAA's rules that did not allow any name, image, and likeness compensation violated antitrust laws. He won that case, and as a result of that case, athletic scholarships were raised to the cost of attendance. The judge in that case also, as a remedy, said that schools should be allowed to give up to $5,000 per year to their student athletes. That part was overturned on appeal by the Ninth Circuit, so the only thing that came out of that case was the cost of attendance scholarships. Then, while also representing the Big 12 and Conference USA, who were defendants in this case, I worked on the Alston case, which has been in the news recently, and which I'll talk about a little bit more later. That was another case where the judge found that NCAA limits on compensation that schools could give to the athletes violated antitrust laws. And I'll talk a little bit more about the changes that will likely be coming as a result of that case later. In addition to those, I've also recently been assisting some universities and others with name, image, and likeness considerations, which is going to be the focus of what we talk about today. So first, name, image, and likeness, it's a term that's very popular these days. It's thrown around a lot, but I'm not sure if everyone knows exactly what it is and where the term comes from. So the phrase comes from what is known in the law as the right of publicity. And it's a right that comes from state law, and it's a right that every person has. And it's usually described as the right to control, profit from the commercial use of your name, likeness, or your image/persona. And the purpose of these laws is to protect from the loss of value that results when someone uses your identity, name, picture, for commercial purposes without your permission. So in the college athlete context, where name, image, and likeness comes up, and the types of things that college athletes will be able to profit from most likely in the future through their name, image, and likeness rights are things like athlete work product, which would include if an athlete wrote a book, if they create some sort of athletic supply, or they come up with their own line of athletic apparel, or if they have their own YouTube channel. It could be athletic related, it could be non-athletic related, just something that the athlete, he or she creates. Then there's third-party promotional activities, which would be an athlete being in a commercial, endorsing a product on social media, which when athletes are presumably allowed to profit from their name, image, and likeness, social media is going to be a huge part of it. It's very easy for an athlete to go on Instagram and plug a product, a restaurant, whatever it would be. It's very simple. And there are actually companies like Open Doors and some others who make it very easy for brands and athletes to connect, and for athletes to just send out an Instagram post, a Twitter tweet, something on TikTok to promote a company.
As companies or people are starting to evaluate and say, this is how much our student athletes are worth, that seems to be about 95% of where they're getting their numbers, is that their social media side.
Yeah, exactly. For example, Open Doors, who I mentioned, they work with a lot of professional athletes, and so they know, based on, if you have this many followers, here's how much a brand is willing to pay for one tweet, for one Instagram post. And so Open Doors has actually put together a lot of numbers I've seen where, let's say Trevor Lawrence, if Trevor Lawrence could profit off of his name, image, and likeness now, here's how much he could, here's how much compensation he could get this year.
Sure.
And it's a lot of money.
It's a lot.
They've done it for other athletes too, not just the football players and basketball players that a lot of people know. I've seen for like a Nebraska volleyball player, the numbers up in like the $40,000 range.
Yeah, I was gonna say, if people haven't dialed in to see what a tweet or another social media endorsement is worth, it's significant. It's very significant dollars.
Right, and it's all based on the number of followers that person has. So the more followers they have, the more value their endorsement carries.
Mm-hmm.
Other categories are autographs. So an athlete could sign autographs, get paid for that. Merchandise, memorabilia, used equipment. Merchandise would be things like jerseys with their names on the back, memorabilia, bobbleheads, used equipment. I watched a webinar about a month ago where some people from the NCAA who are involved in drafting proposed legislation on this issue have said they're planning on their legislation allowing athletes to sell used equipment. So uniforms, bats, gloves, whatever it may be.
Mm-hmm.
So that was interesting, something I hadn't really thought about. Athletes would be allowed to give lessons in their sport and then hold camps in their sport as well and make money off of those. So right now there are 3 sources of potential name, image, and likeness legislation out there. So you have the states, some who have already passed legislation, and many that have pending legislation. Then you have the federal side. They're starting to get involved in proposing and drafting legislation. There have been a few hearings held in the Senate on potential name, image, and likeness legislation. And then you have the governing bodies themselves, NCAA, the NAIA, who are also drafting their own proposed legislation. So there's a lot of moving pieces right now, and it's kind of a question of which of these 3 is going to end up being the governing law or legislation for the issue.
And everybody thinks they ought to be the one.
Right. There can only be one, most likely.
Right.
All right. First, I'm going to start talking about some of the state level NIL legislation. So as I said, there are 3 states that have passed their legislation. The first was California. Their SB 206 was introduced early 2009 and then signed in September of February of 2019, and then signed in September of 2019. I'm sure a lot of you saw they had it on TV. Gavin Newsom was with LeBron James and some college athletes, and Nancy Skinner, who was the legislator in California who introduced and was the driving force behind the bill. California law does not go into effect until 2023, however. The second to pass a college athlete name, image, and likeness law was Colorado. They introduced theirs in early 2020, signed it in March 2020, and like the California law, it doesn't go into effect until 2023. And then the most recent law that was passed is in Florida. That was signed about a month ago, 2020, and it goes into effect 2 years earlier, well, I guess a year and a half earlier than the California and Colorado laws on July 1st, 2021. So the Florida law has put some pressure on the other parties who are considering their own legislation to work faster and to get either legislation passed or introduced before the Florida law goes into effect.
Because a year is a blink of an eye in this situation.
Correct. That date will come very quickly because it's not an easy process for the NCAA to pass legislation or federal government, especially considering everything that's going on with coronavirus right now.
Sure.
So California was the one that really got all of this started when they introduced their law and then eventually got it passed, and then other states started to pile on. The NCAA took it more seriously, and the federal legislators started to think about it more as well. So in addition to those 3 states, there are 31 other states that have pending legislation right now. And there are a number of those that have effective dates of 2020 or 2021, and some of those effective dates are before the 2021 dates are before Florida's effective date. So it's possible that when state legislatures open back up later this year, that one of these other laws gets passed with a 2020 or a 2021 effective date. That could even be in effect sooner than the Florida law. With everything that's going on with coronavirus, it's probably not going to be high on the priority list, but it's a very real possibility that another state could pass a law. We'll just have to see. So the California, Florida, and Colorado laws are the ones that have been passed. In addition to allowing college athletes to profit from their name, image, and likeness, they have some other similarities. All 3 of these laws will allow college athletes to have agents or attorneys to help them with marketing themselves for name, image, and likeness deals and negotiating those and contracts, things of that nature. They all have provisions that say name, image, and likeness deals cannot conflict with an athlete's team or school contract. So, for example, if a basketball player is on a team that has a deal with Nike, they wear Nike shoes, Nike uniforms, he couldn't have a deal with Under Armour that says he has to wear Under Armour shoes in the games, since that would conflict with his team's contract.
Could they outside of, we'll get in the weeds here a little bit, but could they outside if the school athletic department had a deal with Coca-Cola, could they then turn around and tweet out about Gatorade, which is a Pepsi product, or is that?
Yeah, that's a good question. I think all 3 of these laws have provisions that say, outside of your time as a student athlete on your own time, you can do exactly what you just described. While you're playing or practicing or representing your school, you couldn't be carrying.
Then you're a coach.
Yeah, exactly. But on your free time when you're at home, you can send out a tweet about Pepsi.
Okay.
And then they all have provisions that say athletes must disclose any name, image, and likeness deals that they enter into their school. They have different ways you're supposed to do that in different timelines, but they all have similar provisions that say those deals must be disclosed. But they also have some pretty significant differences. In Florida, there's a provision in their law that says any compensation earned from a name, image, and likeness deal must be commensurate with market value. And the law does not define what that term means, what market value is. From what I understand, the Florida Department of Education is going to have to draft regulations that determine how market value is defined, who's going to look at market value, who's going to look at deals and say, yes, this is commensurate with market value, or this is not. So that's still to be determined after those regulations are drafted. The Florida law also has a provision that says name, image, and likeness compensation can only be provided by a third party that is, quote, unaffiliated with the athlete school. So in the whole name, image, and likeness issue, a big sticky point for a lot of the schools has been booster involvement. So the Florida law, as I read unaffiliated, again, that term is not defined in the law that passed, so it'll have to be further defined. But unaffiliated to me means that there are no booster NIL deals, at least in Florida, under that law, which California and Colorado's laws do not have a similar provision. That was probably added, in the legislative process and negotiating, get the law passed. Another significant difference with the Florida law, the way the law is drafted, it does not tell the NCAA what it can and cannot do. It doesn't say, NCAA, you can't have rules that don't allow college athletes to profit from their name, image, and likeness. It just says that Florida schools, you have to allow your athletes to have the ability to profit from their name, image, and likeness. And I'm pretty sure that law was drafted that way to avoid a lawsuit. When the California law came out and was passed, the NCAA said, we're likely going to sue California to prevent enforcement or enactment of this law. And I think the Florida law was drafted that way to try and avoid a lawsuit or avoid losing a lawsuit if the NCAA did sue them. The California law has a few interesting things in it as well. One is that it does not prevent a school from giving name, image, and likeness compensation to its athletes. It only prevents schools from giving name, image, and likeness compensation to prospective athletes, so recruits. The Florida law and the Colorado law specifically say schools cannot give name, image, and likeness compensation to their athletes. The California law allows it. And unlike the Florida law, the California law does tell the NCAA what it can and cannot do. And in addition to the conferences and the schools, it just says all three of those entities, you cannot have rules that do not allow athletes to profit from the name, image, and likeness. The Colorado law, I don't think it was that well drafted. It has provisions in it that were sort of contradictory, in my opinion. So it says, first, an athletic association shall not prevent an athlete from earning NIL compensation. That's pretty easy to understand. Then there's a provision that says, except as may be required by the rules or requirements of an athletic association of which an institution is a member, an institution shall not uphold any rule that prevents or limits an athlete from earning NIL compensation. So when you read those, they're sort of contradictory. What I think that the drafter of this law, or whoever was behind the law, was trying to get across was, NCAA, you can't completely restrict college athletes from earning NIL compensation, but you can have some limits on that, like the market value limit that Florida has, or the booster limit that Florida has. I think that's what they were trying to do. The Colorado law is also unique because it allows athletes to bring actions for injunctive relief to enforce the law. So they could sue the NCAA, they could sue their school, they could sue their conference. I think those entities are preventing them from entering into NIL deals that are contrary, that don't allow them to enter into deals that the Colorado law does allow them to enter into. The California and Florida laws do not allow that. All right, we'll move on to federal legislation. So there has been a federal bill introduced that would allow college athletes to profit from their name, image, and likeness, and that bill was introduced by Senator Marco Rubio on June 18th of this year. That bill was endorsed by the NCAA's NIL working group and the NCAA's Board of Governors, so it has NCAA support. It's a very simple bill, is how I would describe it, and it leaves a lot of authority with the NCAA to draft its own legislation. The law says by June 30th of 2021, the NCAA must do three things. One, they must institute a policy that allows athletes to earn name, image, and likeness compensation from third parties. Two, it must have a policy that allows athletes to obtain professional representation with respect to NIL deals, so agents, attorneys, other service providers. And that the NCAA must create rules for the administration of its name, image, and likeness policy. And then under that section, it tells the NCAA, here are four things you have to have covered in your NIL legislation. First, there's a disclosure requirement. So athletes, at the time they would sign any NIL deal and at the time they would receive any compensation from the deal, they would have to disclose that to their school and the NCAA. The bill says that the NCAA must put in place rules that preserve the amateur status of college athletes. It doesn't say what those rules have to look like or what they have to be. It just leaves that up to the NCAA.
Sure.
It says that NIL rules must ensure the appropriate recruitment of prospective college athletes. So similar to the California law, that would probably mean that schools, boosters, you can't promise recruits NIL deals in an effort to get them to come to your school. But again, it leaves the NCAA, leaves it up to the NCAA to draft those rules and draft them as they see appropriate. And then it says the NIL rules must prevent illegitimate activity with respect to boosters seeking to recruit or retain college athletes. So that would be the same for what we just talked about with the recruits, but also trying to entice someone to transfer to another school. Or there's been a lot of talk about sham booster deals where a booster just wants to give a guy some money, but they say it's an NIL deal. It's really not an NIL deal. It's just a way to pass the money out to an athlete. Right. And again, it leaves up to the NCAA to figure out what those rules actually are going to look like and how they'll be put into place.
So it's almost like a simple bill that's been proposed, but they've provided a lion's share of the initiatives that the NCAA needs to address and draft.
Correct. And then it leaves it, the drafting part goes to the NCAA. All the hard work goes to the NCAA.
Yeah. Well, right. Okay. But then at the same time, so the NCAA established some they were pleased with the legislation, I guess, but then there are a couple voices that came out adamantly opposed. But do you have a sense for kind of what the reality is? I mean, the loud voices get the attention, but is there support or anti-support for the federal legislation, or is anybody even bothered by it right now, given all else that's going on?
There's definitely some support for it. There's definitely people that are against it as well. I don't think in its current form it will pass. I'm going to talk about a few more provisions it has, and one of those is why I don't think it will pass.
Okay.
The first
one right there.
The second one, actually. So, in addition to the things that is covered, the Rubio bill has a provision that would preempt all state-level NIL laws. So if the Rubio bill passes, Florida law, the California law, the Colorado law, they go away. They're not effective. Any of the other laws that would pass, they would also go away. So this is what I think is the sticking point for a lot of people. The law also has a provision that creates a safe harbor for the NCAA and its member schools from being sued for adoption or enforcement of the NIL bylaws that they're tasked with drafting under the bill. And a lot of people have called this an antitrust exemption. Basically, it would not allow athletes, who are usually the plaintiffs in these types of cases, from suing the NCAA or the member schools and saying they colluded on the rules they created and that they violate antitrust laws, has become a big issue because there have been a lot of antitrust lawsuits
Sure.
filed against the NCAA and the conferences recently, and they'll probably continue on for a while unless there's some sort of antitrust exemption put in place. But a lot of people have said it's just not politically possible to get a law passed with an antitrust exemption. So that's why I don't think, at least in its current form, that the Rubio bill will pass.
Okay.
The only person tasked with enforcement power under this law is the Federal Trade Commission. The Rubio bill also excludes the NAI and the National Junior College Athletic Association, so it leaves them to craft their own laws or their own bylaws on NIL if they choose to. In addition to the Rubio bill, there are definitely going to be some other bills introduced that are currently being worked on. One is being worked on by Representative Anthony Gonzalez from Ohio. He's a former Ohio State football player. He played in the NFL for a number of years as well. I don't think anyone has seen a draft of what he's working on, but he has said that it will include preemption of state laws like the Rubio bill. They'll have what a lot of people refer to as guardrails around like booster activity, recruiting, things like that. Gonzalez has said, though, that his bill will not have an antitrust exemption because he doesn't think right now it's politically possible to get a bill passed with an antitrust exemption. Another bill that's currently being worked on is by Senators Wicker and Moran. And I think, and some other people have said, they think this is the most likely bill to move forward just because the positions that those two senators currently hold. Wicker is the chair of the Senate Commerce Committee, and any NIL bill will have to go through that committee before it goes to the full Senate. So he controls the bills. And then Moran is the chair of a subcommittee in the Commerce Committee that's focused on name, image, and likeness legislation. Senator Wicker held a hearing, I think it was July 1st, on potential NIL legislation. And Senator Moran held a hearing a few months ago. I can't remember exactly when it was, February, March maybe, on the issue as well. So they're very aware of the issue, and they're currently drafting a bill that will be introduced sometime later this year. And then you have Senator Chris Murphy. He has been very focused on college athlete issues over the past year or so. He's issued a few reports on student athlete well-being over the past year. He recently said he's also going to introduce a bill on the NIL issue. He actually was trying to work on a bill together with Rubio so they could introduce a bipartisan bill. He said there were a few sticking points and they just couldn't agree on, so Rubio went ahead and introduced his bill. He felt some pressure to get it introduced since he was from Florida, and Florida had passed their state law. So he said he's going to introduce a bill later this year. And then there are some other members of Congress who've also focused in on this issue. Richard Blumenthal from Connecticut, Emmanuel Cleaver in the House of Reps from Missouri, and then Mark Walker, who's in the House of Reps from North Carolina, or some other people who have been mentioned as maybe working on their own bill or working together with the other people on this list on a bill. So there will be a number of bills issued or introduced this year. It's just a question of which one moves forward. As I said, my money would be on the Wicker and Moran bill just because of the power they have, or some sort of combination of all of the bills that Wicker and Moran would then introduce. All right, now I'm going to move on to some governing body legislation on the issue that has either already been introduced or will be introduced. So the NAI, it doesn't get as much attention as the NCAA. Schools are generally smaller, don't have as big a budgets, not on TV as much as the NCAA schools, but they have drafted proposed legislation on the NIL issue. They actually released it in early March of this year, and they were going to vote on it with their membership on April 1st, but coronavirus got in the way of that, so now they're scheduled to vote on their proposed legislation on October 4th at their fall meetings, which are actually going to be here in Kansas City. Their proposed legislation is also very, very simple. It does not have a lot of restrictions on it. basically it says athletes at NAIA schools can receive compensation for the use of their NIL to promote any commercial product or enterprise or for any public or media appearance. So very broad. Um, the NIA rules do allow any commercial endorsement or any NIL deal an athlete enters into to reference the athlete's status as an athlete and also to reference the athlete's school, which has been an issue in considering this, whether school trademarks would be allowed to be used in endorsement deals or not. The NAIA said that's fine. Athletes would also be allowed to have agents and attorneys. The only real requirement under the law besides allowing NIL deals is that athletes would have to report deals to their schools that include references to their participation in athletics. So not much of a limit. That's the only limit that the NAIA really has in their proposed legislation, and there's no limit on value like the Florida law has.
And when you mention agents and representation, I would assume the agents also covers just marketing organizations or marketing companies?
Yeah, correct. Some of them define what an agent is, but the NCAA legislation, I know that they have, they're well aware that there are going to be other types of organizations besides your traditional athlete agent that athletes might want to work with, and that might want to work with the athletes, like the marketing companies or whoever, tax professionals, things like that. Okay, in NCAA legislation, there's been a lot in the news about it over the past year. There have been reports released. The Board of Governors has approved moving forward with drafting NIL legislation. There is a working group right now that's working on drafting that legislation, and they're supposed to have their initial legislative proposal drafted by September 1, and then final legislation drafted by November 1. And then that legislation is supposed to be voted on and approved at the NCAA's convention in 2021. And then the effective date is supposed to be before the Florida law would go into effect, so by June 30th of 2021. And then it would apply to the 2021-2022 school year. Some likely components that will be in the NCAA legislation, there's likely to be a disclosure requirement, like some of the other laws require. Any NIL deals will have to be disclosed to the school, possibly the NCAA, possibly a third-party administrator if a third-party administrator is part of whatever ends up being the governing process for NIL for college athletes. The NCAA legislation will allow athletes and other service providers like attorneys, marketing professionals, tax professionals. There will be a conflict provision. As I discussed earlier, athletes will be able to enter into deals that conflict with their team or school deals. It will also allow schools to say that athletes can't enter into deals with certain brands that conflict with the school values. So if you have a Jesuit school or Catholic school and there's a certain product that is not in line with their values, they could say, athlete, you're not allowed to work with this company or endorse this company.
Got it. So kind of it's not a company or product that we would allow as an endorsee or a sponsor at the university. Therefore,
right.
you ought not do that as well.
Right. Same with the NCAA. A lot of things that are mentioned are gambling, alcohol, things like that.
That makes sense. And assuming, let's just play it fast forward, things go through in the January 2021 legislation is approved at, I assume, the NCAA annual conference. Do you expect that to be immediately invoked, or does that kick in that summer? Or do you expect a longer term?
The effective date is supposed to be June 30th, 2021.
Okay, so it's quick.
Yeah.
Much faster than I would say typical NCAA legislation.
Yeah, yeah, they definitely put this
They
on.
have to, I guess. Yeah.
Yeah, with the Florida law being passed has really put everybody's feet to the fire and made them have to work faster than they might normally work. The NCAA legislation is also, it's likely to have an athlete education component, so schools would be allowed to educate their athletes on the law or the rules and or law, depending on what's the governing legislation. What the law is, how they have to, what they have to do to comply with it, what to do, what not to do, things like that. So some potential components that have been thrown around that might be in whatever proposed legislation comes out. There may be a market value provision, like in the Florida law, that says any deal has to be commensurate with market value. Institutional marks is a question right now, whether trademarks of a school could be used in endorsement deals.
And I find that one interesting simply because some lawsuits in the past on the licensing side where Alabama, for example, won, as did Auburn, but cases versus non-licensees who were just using their colors
Right.
and nothing else. But the courts decided that that those colors are property of the university and you can't use that.
Right. And I think with college athletes being able to profit off of name, image, and likeness, I think it's going to bring a lot of infringers out of the woodworks. Especially, I can just imagine a lot of counterfeit jerseys with the star quarterback's name on the back being sold,
Absolutely.
or bobbleheads or whatever. So it's going to, bring a lot of enforcement issues, policing issues on IP for sure. I think booster involvement is going to be an issue in NCAA legislation, whether boosters will be allowed to provide NIL deals, whether they won't be, or what kind of restrictions there will be on boosters. Pre-enrollment issues. Will high school athletes, if they've already profited off of their NIL, will they be allowed? Will they have eligibility at the NCAA? Rules like in the California law, will schools be able to talk about potential NIL deals that athletes can have if they come to their school, things like that. And then a third-party administrator will be a big issue. The compliance issues with NIL, it brings up a lot of issues, and from what I've heard, a lot of schools are already overburdened on the compliance side, and it's expensive to hire other employees just to deal with another issue. So an issue or a potential solution that's been thrown out is a third-party administrator that would review all the NIL deals to see if they comply with the law or NCAA legislation. So that's something that is to be determined whether a law or legislation will include a third-party administrator or not. All right, so preparing for NIL legislation, there are some things that schools, conferences, whoever can do to get themselves ready for NIL legislation. For it's unclear which law, whether it's going to be the NCAA's legislation, whether it will be a federal bill. If it's still possible a federal bill doesn't get passed before state laws go into effect. If that happens, I assume that a bunch of other states will quickly pass their laws so that Florida doesn't have this perceived recruiting advantage because athletes are able to get NIL deals.
Of course.
So there's a question of, are you going to use your in-house compliance people? Or are you going to use outside providers? There will definitely be some outside providers who will be familiar with the legislation or the law and can alleviate some of the compliance concerns for schools who may already be overburdened with their compliance and don't want to hire another employee just to deal with that issue. Schools need to consider what kind of NIL counseling or education they're going to give their athletes. As I said on the previous slide, it's likely that the NCAA legislation or any legislation that goes into effect will allow schools to educate their athletes on the NIL laws and how to comply with those. So I think that will be an important thing for schools to do to make sure their athletes aren't getting into trouble with eligibility issues. How are schools going to review the signed deals? Say an athlete goes out, signs a deal. This would it could be different if there's a third party administrator, if there's not. But I think either way, a school is going to want to know what deals their athlete has signed before they go out and start doing these endorsements, where they start sending out tweets and
Right.
Instagram posts and whatever. You don't want to be caught off guard by, maybe it's something you're not real happy about an athlete, the product, like we said before, it's something that you're not really excited about, and it
And
doesn't
that goes
align
into
with your school.
that goes into that compliance side as well. Now we're talking
Yeah,
about a really different type of compliance than we ever had to deal with before.
right.
So when you talk about like a third party provider, is that how has it been? Has anybody identified how those third parties would be compensated, or would that be an NCAA paying for that third party provider?
Um, I've I haven't really heard much from the NCAA on how they would be paid, but I have seen. I don't know if I'm sure some of you are familiar with the Drake Group. They have a plan that they've put out that would include a third party administrator, and each school would pitch in a little bit of money to support and pay for the third party administrator, and then there would also be the third party administrator would take a small cut out of every deal, a
Okay.
very small percentage to help fund that third party administrator as well.
But it still seems like schools would probably need to consider additional employees or additional staff just to keep control of everything that's going on.
Right.
So it's
Or
interesting that a third party provider could take a cut of that, but the school themselves is going to have additional resource needs with really very little opportunity for compensation.
right. Yeah. The way schools can receive some compensation from this is if institutional marks are allowed to be used in deals, then they would be getting some money for allowing their marks to be used in commercials or jersey sales, things like that.
Right. Got it.
Yeah. Um, so let's see. Whoops. In addition to those things, schools are going to have to consider what they want their disclosure requirements to be. Um, when do deals have to be disclosed? Um, they need to determine whether they're going to work with their athletes on selecting agents, attorneys, other service providers. I think it's likely NCAA legislation, if that is the effective rules, it will allow schools to assist their athletes with selecting those types of service providers. Schools are going to need to work on their conflicts policy. What conflicts with a team deal, a school deal? How are they going to go about making that determination? What's the process if an athlete doesn't agree with that determination? Is there going to be some sort of conflict resolution process?
Or their
Also,
agents, attorneys, and other service providers don't agree.
yeah, exactly. Right.
Yeah. Yeah.
And then the institutional marks, which we've talked about a few times, whether our school's going to allow institutional marks, if they're allowed to do that. Schools could still choose not to. All right, so cover the name, image, and likeness legislation. I really quickly wanted to go over the Alston decision, which I referenced earlier. So that decision that the trial court came out in 2019, and in that case, it was a class action brought by former and current basketball and football student athletes. They were challenging the NCAA's limits on the amount of compensation that schools can give to their athletes in athletic scholarships. The same court in O'Bannon, same judge in O'Bannon, they determined that the NCAA's limits on compensation to their athletes do violate the antitrust laws, and as a remedy, the judge removed all limits on what she called educationally related benefits. And she specifically named some things like computers, post-grad scholarships, so like scholarship to law school, med school, business school, study abroad. But there are a lot of other things that can be considered educationally related benefits. As her remedy, she also said that schools can give cash payments or other gifts for academic or graduation awards or incentives to their athletes up to $5,600 per year.
Huh.
So the NCAA appealed this decision to the Ninth Circuit, the Ninth Circuit affirmed the decision, which means it upheld the trial court's decision. So the NCAA has said they're going to now appeal this to the Supreme Court. They've asked the Ninth Circuit to stay the enactment of the trial court's decision, which would put on hold the allowance of the educationally related benefits and the academic awards. The NCAA also appealed O'Bannon to the Supreme Court. The Supreme Court did not take that case up. The Supreme Court takes up a very small number of cases, so it's, if you were going to bet, it's likely that the Supreme Court is also not going to take this case up. So that means the trial court decision would stand, and schools would be allowed to give unlimited educationally related benefits and the academic payments or gifts up to $5,600 per year. So this is another compensation issue that could come sooner than NIL, and this is different because this is money that schools themselves can provide to the athletes as opposed to or the third parties with the name, image, and likeness. And it's been in the news, a little bit when the decisions first came out, and then when the Ninth Circuit affirmed it. But the name, image, and likeness issue has taken up a lot more airtime in this decision. But I think this decision is just as important as whatever happens with NIL, because it could have a big financial effect on athletic departments. So some considerations for the Alston decision, are you going to provide additional educationally related benefits? What are those benefits going to be? Is it going to be, are you going to have a policy for all athletes, or are you just going to, are you going to wait until they ask? You only give it to certain athletes. So those are things that will have to be decided.
And these are very much on a school by school basis, correct?
Correct, exactly. And then are you going to provide the academic awards and incentives? You can give, as long as the decision stands, you can give people cash for graduating. Or I could envision, if you get a 4.0, we'll give you $1,000, something like that. Or if you meet whatever GPA benchmark for your team, we'll give you X amount of dollars, things like that.
So that starts playing into from way back in our first webinar this year with Forward Progress and John Shuki. That starts getting into the into his world of APR and NCAA academics. Yeah,
it really gives an potential incentive to get that APR up there.
Yeah, beyond eligibility.
Yeah. So you're gonna have to decide, are you gonna do these things? And then if you decide you are, how are you gonna fund those things? Especially now there's coronavirus. I don't think anyone is gonna have a lot of extra cash. So
extra cash is not a topic that people are discussing right now.
No, exactly. All right. I think that covers everything I wanted to talk about. I think I almost stayed within my time.
Given the subject matter, the fact that we could squeeze it inside a 60-minute time window is impressive, no matter how you look at it. Well, there are a question or two left that I will get to you directly, Mitt, and have you, because there's a question. There are a couple out there that are strong enough that I think we could continue for another hour on the individual questions, which I don't think is anybody's best interest today. But I'll share those with you, Mitt, and you can reach out directly to the questionnaires. But certainly an enormous thank you. That's great information. I consider myself to be up on this subject, and I learned a few things, so that was great. For those of you that have gone through this or maybe caught part of it, please do remember we have recorded this. We will load it again probably tomorrow. You'll have in an email a link to be able to find it. You can share that within your athletic departments or within your conference or wherever it makes sense to do so. And then touching on it a little bit on a comment just a moment ago, going into next week, next week's conversation is going to be about revenue. And let me share my screen here. So I can show you what we've got coming up. So next week, here we go. So we're talking about alumni, student athlete alumni, and increased giving and increased investment into your athletic department. So it's making sure that former student athletes are engaged and involved. And how does that happen? It doesn't just happen, as we all know. And I think probably most of you know that student athlete giving is actually at a lower per cap and percentage than from general student population. So how do we turn that trend around a little bit? So make sure you register with us to get involved in that. And then certainly for our final one in July as well, as we talk about screening, and that screening of personnel, certainly staff and job searches, that sort of thing, but also screening student athletes and knowing what you're getting on the way in the door for prospective student athletes. So register to join us with those. And in the meantime, if you have any questions, thoughts, concerns, ideas, please do share them. You can reach out to Mitt directly, and his email is at the bottom of the screen here. Certainly you can find me at the top of the screen, or you can find Snodgrass Partners, the group that's pulling all these great people together. So, and snodgrasspartners.com is also the place where you can register and or find any of the recorded webinars we've done to date. So with that, I will say thank you to everybody for joining us today. Certainly, Mitt, one more time to you. And until next week, be safe and be well. Thanks, everybody. I appreciate your time.
Thanks for having me, Peter.
Of course.